Arguments that Kansas lacks jurisdiction over the defendant. Arguments about being a secured party, traveling, not driving, jury nullification. Arguments about the judge, the court, or the state being corporations. Claims that statutes only apply upon consent of the defendant.
Why would you limit that? If those kind of limits are there, then basically it sounds like you guys would be violating by constitutional and civil rights.
Number 25 TR 687, State of Kansas versus Francis F. Hodge. And you are Francis Hodge?
Yes, the living man, Francis Hodge.
Okay. May I have an announcement of appearances, please?
I'm sorry.
May it please the court, the state appears by Noah Haas, Assistant Gove County Attorney.
And you're Francis Hodge III?
Yes, the living man.
Okay. And Mr. Hodge, it's your desire to continue representing yourself?
Yes, sir.
And you're not requesting counsel?
Correct.
Okay.
Well, I mean, the counsel I have is just not a lawyer. That's all.
Okay. And you do understand the potential punishment for these offenses?
I do.
Okay.
According to your ways, yes.
Okay. By statute, count 2 and count 3, for which you're entitled to a jury, if convicted, you could do up to 6 months in county jail and up to $1,000 fine. Count
Yeah,
one,
that's your statutes. Yeah.
count 1 is an infraction, a speeding infraction. That's tried to the court, not to the jury. Okay.
Okay.
And that is subject to a fine if convicted.
Okay.
Okay. Now you've requested a jury, and we've got a jury trial scheduled for Monday, June 29th in 2 weeks.
Correct.
Okay. And you understand you have to be here in person in
Correct.
the Gove County Courthouse.
Yes.
Okay. Currently, count 1 is charged speeding 75 in a 70. That's a traffic infraction. Count 2 is failure to provide proof of insurance, a Class B non-person misdemeanor. And count 3 is driving while revoked, a Class B non-person misdemeanor.
Okay.
Mr. Haas, are there any amendments to the complaint or information? I noticed you had filed an amended complaint on June 12th, 2026. It cites the exact same charges. You've just put it into a little different statutory language.
Clarified the subsections, Your Honor.
Have you sent that to Mr. Hodge?
Yes, Your Honor, we did by mail.
Okay.
And I think email too.
Have you received that, Mr. Hodge?
I received it by mail. Yes.
Okay. So you're fully aware of what you're charged with, and you're not looking to amend those charges any further, Mr. Haas?
No, Your Honor.
Okay. And Mr. Haas, have you issued your subpoenas to assure the attendance of your witness?
I don't think I've done that yet, Your Honor. I have spoken with the officer. He's aware of the date. I can get that in. I can get that done today.
Okay. I'm sure you get that done.
Excuse me, Judge, and Mr. Prosecutor. Could I get your full names? I do apologize.
Yeah.
My full name is Noah Haas.
Noah Haas. Noah, Noah.
Yep.
And Haas, Haas.
HAHS. It should be spelled out on the Zoom there too.
Okay. I'm sorry. What was it? I got two screens up. H8 what?
H is in house. So there's two H's.
Oh,
As in
okay.
house.
HAHS.
S.
Okay, gotcha. And are you bonded as well? Mr. Haas?
Mr. Hodge, that's not an appropriate question at this time. Okay.
What do you mean at this time? What time will it be appropriate?
Well, he is a duly appointed assistant county attorney.
No, I understand that, and every attorney needs to be bonded just like you as a judge.
He's licensed.
No, I said bonded. I didn't ask for a license. I asked if you guys were bonded.
Well, he's licensed. He's sworn in.
Are you required by Kansas statute to be bonded to perform your duties as judicial officers,
We're required to be licensed. We're
but
required
not bonded?
to be elected and or appointed.
But not bonded is what you're saying? You're not
Right.
required to be bonded?
Right.
Okay.
Okay.
And what was your full name again, Judge? I'm sorry.
Just like it says on the screen, Thomas J. Dries.
Yeah, I'm on two screens, unfortunately, on the Zoom, and I can't see that part. I'm typing on my notepad here. Can I go ahead and get your name for the record?
Yeah, Thomas J. Dries. Okay. Mr. Hodge, have you sought discovery and inspection in this matter?
I'm sorry, have I what?
Have you sought discovery and inspection?
Have I sought discovery? Yeah, I'll present everything at trial.
No. Have you sought discovery from the state?
Oh, have I sought discovery? No, I don't see a point to seek it because it's already presented.
Mr. Haas, have you sent any discovery to the defendant?
Your Honor, we have not received any requests for discovery, nor have we sent any discovery materials.
Okay. And have you requested reciprocal discovery?
No, Your Honor.
Mr. Hodge, do you intend to set forth any objection to the institution of the prosecution?
Oh, of course, I do have objections, but being that we already have the trial date already in place, it wouldn't do any good to try to do anything before the trial because we're not going to get anywhere.
Okay. So you're not alleging any defects in the complaint?
I'm sorry. What is that in like plain English? Any defects and complaints? Are you saying, do I disagree with any of the charges?
No, I'm saying, are you alleging that they have charged the wrong crime? Have they charged the wrong date? Have they charged the wrong jurisdiction?
Oh, the wrong crime for sure. Jurisdiction, I'm still up in the air. I'm not sure about, but yes, the wrong crime. Yes.
Okay, you don't believe you were in Gove County?
Oh, I didn't say that. I got pulled over in Gove County, so we know I was in Gove County.
Okay. Are you claiming any violation to your right to speedy trial?
No, I think this is speedy. I have no complaints against that part.
Are you claiming any alibi?
There's no alibi to be had.
Okay. Are you intending to file any motions to suppress during the trial?
I won't know that until the trial.
Okay, the trial is set for June 29th. It is one day. It is a 6-person jury. Each side has 3 peremptory challenges. So we will qualify 12 jurors and strike down to 6. Okay. And does either party anticipate filing any motions in limine?
And what?
Motions in limine, which is
Okay.
that's
Yeah.
a motion to limit what can be presented.
Oh, no.
Yes, Your Honor, I do intend to file a motion in limine
Concerning
anticipated meritless legal arguments.
What does that mean?
such as what?
Arguments that Kansas lacks jurisdiction over the defendant, arguments about being a secured party, traveling, not driving, jury nullification, arguments about the judge, the court, or the state being corporations, claims that statutes only apply upon consent of the defendant.
Why would you limit that?
How long do you anticipate needing to get that on file, Mr. Haas?
I believe I could get it filed within the next couple days, Your Honor.
Okay. Can you do it by the end of the week?
Yes, Your Honor.
Okay.
Would that filing be ruled as okay to have those limits?
We'll take that up at the time of at the start of the trial. We'll take
Okay, because I would need to know that before the trial, because if those kind of limits are there, then basically it sounds like you guys would be violating by constitutional and civil rights if it's accepted.
Well, we'll take those up at 8:30 in the morning on the 29th.
Well, a part of me showing up, I could take a warrant, but I think it would be more fair if that is known ahead of time, because there won't be no sense in me playing those kind of games if I'm unable to bring the fullness of what I may bring, what I have to bring, representing myself to the table. There shouldn't be no limits. You should be able to hear everything, especially when it comes to the law.
Well, he's filing his motion by Friday at noon.
So shall I file a motion to have no limiting?
If you wish to file a response, you must file that by next Wednesday at noon.
Okay. All right.
I'll make sure I email you immediately after filing, so you should have enough time. As well as we'll mail it out too.
Okay. And can I also get your email so I file as well?
Yep. I have sent you some correspondences, so you might be able to find it, but it's Noah. That's Noah.
Okay. Now I'm talking about to the judge. You said you was going to email the judge.
I'm going to email you the motion right after it's filed, so you have as much time as possible.
Okay, I appreciate that. But I would also like to file my motion to the judge just like you. I just need an email if that's okay.
You'd file it with the court.
Okay, and what's the court's email?
So, Judge, he can't file by email with the courts. He's a pro se litigant. He's going to have to either fax it to the Gove County clerk, or he's going to have to mail it. We can't take an email filing.
You'll have to fax it then.
Fine. Yeah, and can I get the fax number?
It's 785
785
938
938
2312.
2312.
That's correct.
Okay. Thank you very much. I appreciate it.
You're welcome.
And you need that motion in by next Wednesday, you said?
Yeah,
Or-
by noon on the 24th.
Okay.
Sandy, could we set up a Zoom hearing on the 25th?
Okay, let me look. For like a review of this.
On the motion in limine.
Yeah, June 25th.
Yeah,
We sure can. You've got time. What works for you, Noah?
Give me just a moment here.
And what is that called again? A motion of limity?
motion in limine.
Oh, in limity. Okay, thank you.
Limine.
Line. Okay, got it. Thank you.
I could do most of that day, Your Honor. I do have a Zoom hearing at 3. The earlier morning would work best for me.
We can do morning. We can do you want to do a 10 o'clock? Mid-morning?
10 o'clock works.
Okay.
There's all these extra steps that's interfering with my work. So how can we limit some of these steps so I can stop missing work? Or can I just charge my time from work off to the courts?
Well, you can't charge your time to the courts, but Mr. Haas will file the motion in limine. You'll have a chance to respond to it. You want a hearing prior to trial, so at your request, we're setting a Zoom hearing at 10 o'clock Friday or Thursday, the 25th.
I didn't request anything before the trial. I just asked
You're
about the motion.
requesting the court to rule on the motion prior to trial.
Okay. Oh, that's what you're saying. Okay.
That's what you just
And that
requested.
means right. And I have to miss work for this small period of time for that is what you're saying?
Yes, you'll need to appear at that hearing because you've requested the hearing on the motion in limine. So we'll have that on the 25th at 10 o'clock.
Okay. Yeah, I got you. I just wanted to be clear. I want to
Okay.
make you have an understanding.
And
Appreciate it. Thank you.
Then you'll be here for the trial on the 29th. Okay.
Okay.
Are there any questions of law that either party think will arise during the trial?
I think Mr. Haas and I, we already had such a discussion and it led to nowhere. So I have that's the only reason for the motion in limine form on my end.
Okay. Mr. Haas?
Your Honor, the anticipation of any matters of law has already been outlined in my request for the motion in limine. I don't see, without defendant letting us know now, I don't anticipate anything that I haven't already mentioned.
Okay.
And also too, I don't know anything vice versa. You haven't let me know anything either. So we're both in the same boat.
I suppose, Your Honor, that I do have a motion. If it's filed too late and we're not going to hear it, that's fine. But I suppose that's an additional issue of law that's pending.
What is that?
So I did file a motion to reconsider for bench trial. I do believe the law supports that. You did make a ruling on it already, but it was based on the lack of a written request for jury trial on the defendant. And I mean, I kind of lay it all out in the motion, but
the judge granted it.
Yeah.
He said there was no need. I didn't need to.
Hang on, Mr. Hodge. Let me speak.
Yes.
The purpose and requirement of that, Mr. Haas, is so that he doesn't show up at a time of a bench trial and say, hey, I want a jury trial. So you have to make your request. He made his request to the court in person, which is as good as filing it in writing. So the court heard his request for jury, and he's entitled to a jury on counts 2 and 3. So
I'm happy. I'm okay with that, Your Honor. I disagree, but I'm 100% okay with your ruling. I object. It's all in the motion.
that's fine. And you've got your objection noted for the record. And if at an appropriate time you wish to take that up with the Court of Appeals, you can do that. Okay?
Gotcha, Your Honor.
Okay. So exhibits, the state, your exhibits will be using numbers, 1, 2, 3, etc. The defendant, Mr. Hodge, if you have any exhibits you're going to file, they must be filed using letters, Exhibit A, Exhibit B, Exhibit C, etc. Okay?
Write that down as well.
Is there any technology or media anticipated at trial by the parties?
Possibly, but it depends on me presenting the exhibits, which I will have photocopies of for everyone.
Your Honor, I do anticipate showing video.
Okay. You must work with the clerk to make sure that you have the appropriate technology in the courtroom and available.
Yes, Your Honor.
Okay. Test it out, make sure it works.
And when you say appropriate, what does that mean exactly? Like if it's on my phone, I need to have that connection or that Bluetooth or Wi-Fi or something connection with the courts.
Well, if it's on your phone, that's a bad thing because then your phone will be taken into evidence. If you're going to admit something, you need to put it on a medium that can be
like a drive.
Trial. Yes, like a drive.
Okay.
Okay.
All right. Thank you. Yes. Yes, Your Honor.
Do either party anticipate any issues with the jury instructions?
No, Your Honor.
I don't know what the instructions are.
Okay.
Can I get that in writing and mailed to me?
Well, it's your obligation to provide any proposed jury instructions you wish to have to the court. Those are the pattern instructions of Kansas.
And I could get those through the clerk's office there.
Well, you'll have to get it online. I mean, you certainly can come into the clerk's office and look at them, but it's a large volume and they're not going to copy it for you.
Okay. And you said online, where do I go to get
Just
that?
look up pattern instructions of Kansas through the Kansas Judicial Council. Any proposed instruction should be cited by number. If you have any requested changes, you must cite them by producing the instruction with the cited change. And Mr. Haas, on your element instruction for counts 2 and 3, make sure you go ahead and submit your element instructions because there are options you have to choose. Okay? And
Yes, sir.
My charges were what exactly again? Speeding.
The speeding is tried to the court, so you don't have to worry about the speeding.
Okay,
The
but
two that are tried to the jury are no proof of liability insurance.
Okay.
That's count 2, and count 3, that you were driving when you were revoked.
Okay. All right. Thank you very much. And that's count 3.
That is count 3. And Mr. Haas, on your amended complaint, you're still indicating canceled, suspended, or revoked. It's not in the alternative. Which one is it?
Suspended, Your Honor.
Was he suspended versus revoked?
I believe so, Your Honor. I'm not 100% certain.
Well, you'll need to, at the time of trial, we'll then narrow it down to whether it is suspended or revoked. That is not an alternative charge.
Yes, Your Honor.
Okay. So any proposed instructions the parties wish to submit to the court must be submitted by June 19th at noon.
Okay.
Again, if you're just requesting an instruction as it is printed in PIC, you just have to give us the number of the PIC instruction. And Mr. Haas, on your element, go ahead and prepare your element instructions for counts 2 and 3.
Yes, Your Honor.
Okay. So the parties need to be in Gove County at the courthouse on the 29th by 8:30 in the morning. Okay?
Yes, Your Honor.
Okay, I have prepared the pretrial order, and we'll file that and send it to the parties.
Thank you, Your Honor.
Anything else we can take up today?
Yes, Your Honor. So our office has a legal intern admitted to practice under Rule 715. I do intend on having him as co-counsel, and according to that rule, I do believe I need approval of the court. So I'm just asking for that approval.
Yes, he can appear with you and sit at your table, and he can act accordingly at the trial under your direct supervision.
Thank you, Your Honor.
Okay. Okay. Get your motion in limine filed and your jury instruction filed, Mr. Haas. Mr. Hodge, make sure you respond by next Wednesday at noon.
The 25th by noon.
No, you have to respond on the 24th by noon.
Oh, 24th by noon. Oh, I'm sorry. Yep,
We'll have a
24th.
hearing on the 25th at 10 a.m.
Right. No, I have that. I apologize.
Okay?
Yep. Yes, sir. Appreciate it.
Okay.
Mm-hmm.
The courtroom takes a dramatic turn when the prosecutor asks the judge to restrict the defendant from making several arguments he expects to hear at trial, including challenges to jurisdiction, claims that he was traveling rather than driving, arguments about the court being a corporation, and claims that the law only applies with his consent. The defendant immediately questions why those arguments should be limited and warns that doing so could violate his constitutional and civil rights. The judge, however, does not make an immediate ruling. Instead, He orders the prosecutor to file the motion by the end of the week and gives the defendant time to respond. A separate hearing is then scheduled before trial to decide what arguments may actually be presented.